Several years ago, in my second decade of practicing law, I learned a lot about estate disasters. My mother's aunt had substantial financial resources saved and invested over the many decades of her life. She and her now deceased husband had saved for old age for security in their retirement years. She owned her own San Francisco home, had a secure pension, and also a large stock portfolio. Then, in her early 90s, she had a caregiver to assist her at a time of her decreased mobility and her limited hearing and other sensory deficits, as well as her lost driving privileges. In the few years before my mother's aunt passed away, my mother and other relatives' home visits revealed their aunt's increasing fear and paranoia of the outside world, accelerating dependency on the caregiver, and multiple delusions. Her world was closing in on her. She had a siege mentality and trusted no one but the caregiver. In time and over the last 3 or so years preceding their aunt's death, the caregiver isolated her from family and friends and neighbors and professionals that the aunts once trusted. An estate disaster unfolded on the very day of her death. When the estate was finally settled many years later, the only winners were the lawyers. There are many roads to estate disasters. Caregiver isolation is only one of them. There are a number of mistakes that repeat with regularity. Dying intestate or without a will is near the top of the list of estate disasters. California law provides that any part of the estate of a decedent not effectively disposed of by will passes to the decedent's heirs as prescribed by California's intestate succession statutes. Intestate succession laws generally provide that the decedent's intestate share of community property is distributed to the surviving spouse. The intestate share of separate property is distributed to the surviving spouse alone if the decedent did not leave any surviving issue, parent, brother, sister, or issue of a deceased brother or sister. The surviving spouse receives one half of the separate property intestate estate, where the decedent leaves only one child or the issue of one deceased child. Where the decedent leaves no issue but leaves a parent or their issue, then the surviving spouse receives 1/3 of the separate property intestate estate. Where the decedent leaves more than one child or one child in the issue of one or more deceased children. Conflicts easily arise when a decedent dies intestate, leaving a spouse or other close relatives along with long-distant and separated relatives. A surviving spouse is generally not too pleased when Bubba and Barney from Alabama, her deceased husband's long-estranged brothers, show up on her California doorstep to claim 2/3 of her husband's separate property estate. A simple will would have kept Bubba and Barney off the porch and back in their Alabama homes. That said, even wills do not apply to property which passes by non-probate transfers or NPTs, since they're not a part of the estate. Examples of non-probate transfers include property where the decedent's interest terminates on death, or any property the decedent held in joint tenancy or trust, transfer on death deeds, and pay on death or POD bank accounts. There's little question that non-probate transfers can be integral to estate planning. The problem arises when the benefiting parties to such transfers were unintended. Real-life problems with NPTs occur when beneficiary clauses are not updated in life insurance policies, IRAs, 401ks, and similar pension accounts. It's not unusual that a former spouse is left as a beneficiary on NPTs. This is okay if it truly is the intent of the decedent that his former spouse benefit from his assets, but the problem occurs when the intent is not clear. Other relatives appear at the decedent's passing to challenge the MPT as an unintended transfer. These cases are often resolved prior to trial, and settlement often splits up the assets. If you'd like to speak to us about an intestate estate disaster, you can call us at Hackard Law 916-313-3030. We represent clients where we think that we can make a significant difference in cases where there is a wrongdoer who can be made financially accountable for their wrongdoing. We represent clients in California's major urban areas, including San Diego and Los Angeles. Santa Clara, Alameda, and Sacramento counties. Thank you.